Thank you very much, especially with this introduction by the special man and special robot here. I hope I can fulfill these expectations. There are quite a lot of expectations following the previous presentation, which was, of course, playing to a full house, and, of course, data security and privacy issues aren't quite perhaps as exciting. But if you have questions, do please feel free to ask them. Those who amongst you knows this building? You're all very silent. It's in Ireland. And you can see this dark blue window in the right corner on the side. That is the Irish Privacy Centre. They deal, authorities, they deal with people's, for example, Facebook, Twitter. And they have, and you can see this tiny window, but in fact there are millions of bits and bytes going through there. Of course, the data giants, they are all, for example, then registered in Ireland because they see how much of a threat that they're going to be facing there instead of, for example, in Germany. My name is Thomas Waetke. My blog, eventfaq.de, is up here. I'm specialized in also event protection and also event. And also, of course, we have privacy involved here. New organizational formats, that's quite difficult. If you've had anything to do with this, we find this, we still find video cassettes quite exciting and, well, exotic. We think they're great because we noticed also that we're also a little bit behind the times in this regard. Now, when we move forward, however, into the future, then we see that, however, this is a little bit of a challenge that we're facing because we're always, a few years behind, as it were. And, of course, there are quite great risks we face. We also have penalties, which are quite high, up to 300,000 euros. And nowadays, of course, that means that I really don't have the security of the legal structure behind me, knowing that 100% I'm in a clear legal zone or not. And I do agree with the moderator. It is a good idea to ask a specialist. But oftentimes you might hear the answer, we don't actually know ourselves because of the situation developing on the ground. So I'd like to start off with a few theoretical aspects. In Germany, we have the national privacy laws as well as the laws at the state level. That's 16 of them. And, of course, as a corporate entity, the federal rule laws apply. And as an individual, then also we have to look at the state-level laws, and then we have to also look at the telemedia laws, which play an increasingly important role. And of course, then I also have to also see that we notice that there are also quite a lot of reminders that are given to different entities. And we see this risk increasing. We ourselves have quite a lot to do with this. And then the highest, in fact, one of my clients' penalties that my clients faced was 250,000 euros. And it was about an audio cassette. The cassette, in fact, he'd left his bag next to the toilet, and then when he came back to it, he found it was missing. And if it was gone, in fact, that is actually his problem and fault, and that was liable for this as well. One important topic is also contract data processing. As a part of the Federal Data Protection Act, we have here a differentiation. The line here is actually at the definition and also delimiting the transmission of responsibilities. For example, event agencies, for example, are supposed to take care of travel details, for example, and that means that data are being transferred. Key is, of course, personal data. For example, personal first names, email addresses, and the like. These are all personal data. When I then either collect, save, or process data on their behalf, on the behalf of third persons, they remain then with the organizer. He remains responsible. And when you give data to, for example, third person, for example, an event agency, the principal and the contractor has to, the principal has to then go to physically check the premises to make sure that things are in order in terms of a server room, for example, and then a contract is then also signed for this data processing, and that might even be also on site, because I am responsible for this to make sure that they are saving information and data correctly and also storing it correctly. So at this point, we have then the organizer, for example, providing me the data, then I'm not responsible I'm not rather allowed by the agency to then use this data, because the lawmaker says that perhaps the organizer could do this themselves. But then, for example, you then need a specialist, either a lawyer or also an accountant, and all of a sudden, then there is a transfer of that responsibility to the lawyer or the accountant. The responsibility is transferred to them, as long as they have the organizer, that is, has the possibility and also the legal option of transferring that responsibility to the third party. So at the top, you see then the controlling function and the supervisory function. In particular, in Bavaria, the data protection authorities actually checked not just the formulation of such data contracts and data processing contracts, but also the fact that they're implemented correctly. And if you cannot prove that as an organizer, then you have a problem, and you will then be most likely subject to penalties, financial penalties. The third point, perhaps you've already heard of this until now. If you'd had data that you could transfer it from the EU to the US, even if it was if it was private, that was allowed because of the safe harbor agreement between the US and the EU. But the European Court of Justice said that that's not allowable, because the US should not be allowed to see these and also access these data. Well, this political agreement is quite simply not sufficient. So since then, the data protection authorities, one after another, are actually looking at corporate entities that are transferring data to the United States, because it's not allowed anymore. Because, for example, they might do that because their servers are physically present there, but legally it's not quite sure what to do now. The follow-on agreement, already the data protection authorities are saying that's not enough. That means that you're not really having what you're finding right now is that you don't have a legal basis for actually transferring data, personal data, to the U.S. So, for example, Google is now building big servers here so that there is no need to transfer certain information and personal data to the U.S. Right now, the big companies, for example, in the north of Germany and also in North Rhine-Westphalia, are quite affected by this. So what are they doing? Sometimes they are transferring their data outside into abroad. And sometimes with the data processors, they're actually moving then wholesale and abroad. But that is not actually allowed at the moment because of the situation. If you have data and servers in the U.S., that right now it has to be dealt with quite carefully because the authorities are looking into this in great detail. Now, I'd just like to bring in a few topics here as regards privacy at events. Let's, however, move on to my next slide, where we start first of all with participants' data. It could just be simply the names or that they're listed on a letters. Of course, names are, in fact, privacy. They're private straight away. So right away, you have to think about what we're going to do with the data. Lists of participants, their names. I can't simply publish them or read them out. I have to keep them secret, and I have to keep, unless they've agreed to have their names or data published, perhaps online even. But that is only acceptable with their consent. Movement patterns. For example, I've been scanned when I went into different events and sessions. Is it just because the question that comes up is it just about having one more person come into the room or out of the room, fire hazards, or are they following me on a personal level so they know exactly where, for example, Mr. Miller is right now or Mr. Meyer is here and that other session? Again, consent is required from the individual. The newsletters. Just one more example as regards movement patterns. There are certain exhibitors who say, for example, I can send you marketing materials, and he needs to then have my personal ID to get to my name. Well, is that okay? Or rather, I look at my event ID here, my address isn't there, it's not written on there. How does that work? Well, he gets the email address from the event organizer, but only if I've agreed to, by prior consent, with the event organizer.
So we're thinking of newsletters sent out by telephone, by fax. Which of you send out newsletters to your customers? Who sends newsletters to their customers? Put your hand up. What do you have to bear in mind when you're thinking about that? In Germany, and indeed across the EU, it's almost the same everywhere. You need consent. You have to have either explicit approval and agreement because somebody signs up to a newsletter, or you need so-called purported or putative consent. That means if somebody is to be sent a newsletter, then you can only do it if somebody has either explicitly or implicitly said that they want to have the newsletter. Now imagine you put an ad in the newspaper. Then a removal company is allowed to call you and ask whether you want them to do the move for you, but only in that case. And there's a court ruling saying that after approximately 1 year, consent to a newsletter lapses. So if you send the first newsletter 1 year after the first agreement to receive the newsletter, it is no longer valid. And you're also not allowed to do cold calling to ask if you can send somebody advertising. You're allowed to ask somebody in person or to send them written communication. The German Federal Supreme Court recently ruled that if you register somewhere or other and receive a reply, then if that reply contains commercial material, advertising material, it already counts as advertising. And you have to obtain separate authorization for that. The same goes for games of chance. Agreement to receive advertising always has to be separate. There always has to be a little box to take saying that you're going to accept advertising mail. Now there's a question of the photographs. There are now court rulings saying that a photograph also counts as personal data. Now generally, if you have a photo or video with a person who's clearly recognizable, you have the privacy rights of the individual. It's possible to identify me here on this video, so there are privacy rights. And the trade fair or MD else can't do whatever they want with this. With this video, I have to be asked in advance and give my consent. If I wish to take photographs of you, I have to ask you for permission beforehand. There are only a very few cases where you can take someone's photograph without asking them. For example, if you're photographing a group or a crowd, that might be difficult. It needs to be an absolutely full room or a football stadium or a concert hall. You're allowed to photograph into the crowd, and the first row can be identified and has to live with that. And there's another new decision that's been taken as well. A new ruling has been handed down saying that if you're at events which are important in terms of contemporary history, you may also be photographed, for example, at championships or at openings. It is possible in that case to photograph without asking for permission. So if you go to an anniversary event, if you go to a sporting championship, you have to reckon with perhaps having your photograph taken without your permission being asked, without you knowing what happens with the photograph. If you don't have those two exceptions, important in terms of contemporary history and topical affairs, or in terms of photographing into the crowd, in all other cases, you have to give your permission and you have to be told what the films or photographs will be used for. It's not enough just to have a little notice saying you may be filmed or photographed. You must generally be informed as to how and where these films or photographs will be utilized subsequently. Now, there's also the question of data protection when it comes to photographs. It's not just a matter of privacy law, but also of data protection law, because a photograph can also be personal data, particularly if the person can be identified. Now, what is interesting is the utilization of your name or address or photograph must be consented to. However, at any point in time, you may revoke that consent. That's the case in data protection law. When it comes to law on protection of privacy, you are not entitled to revoke your authorization. That means that if you agree to your photo being used pursuant to law on protection of privacy, you cannot revoke that consent. There's a new development. The first courts are starting to say, actually, there's a problem here because there's also, at one and the same time, a data protection issue. Under data protection law, you're allowed to revoke at any point in time. So imagine you've filmed or photographed, your photograph appears in a brochure subsequently. You may decide, pursuant to data protection law, that you are revoking that consent and your photograph must be removed from the brochure or the website. That's a huge problem in marketing, and it's difficult to assess its extent currently. If you have a large print run of catalogues, imagine just one person comes along and says, no, actually, I'm revoking my agreement, then You can shred all of those catalogues, which is often rather an expensive business. How do you manage to do this? Well, it's only by reaching an agreement upstream with the people who are involved, and you have to hope that the people don't know all the ins and outs of it in terms of data protection and aren't aware that they can't revoke their consent at any point in time. Moving away from the participant data to the web page or websites. Most of us have got a website. What do you have to bear in mind? Think about cookies and contact forms. Well, let's start talking about the contact forms. If you have a form on your website that people can fill out, there are some new provisions in legislation. First of all, you can only request the requisite data, the maximum amount of data required. If, for example, you have a game of chance, some kind of a competition, you can do it electronically via the website. You can ask for the email address and the name, but not the postal address, as it's quite possible that for this kind of competition or game of chance, you don't need the postal address. You may be able to request information about the date of birth to ensure that the participants in the competition are adults, but you can't ask for any more information if a participant fills out a contact form. The information must be deleted subsequently. You cannot simply retain the data ad infinitum once the matter has been dealt with, and before the contact form is filled out, you must tell the user what will be done with the data. It generally doesn't suffice to have the information you have in the legal notice on data protection. It generally makes sense to put it next to the messages. There have already been the first disciplinary warning letters on this. According to the Telemedia Act in Germany, provisions have to be taken to ensure that data transfer from the contact form to your server is protected. In other words, it has to be encrypted. So if you're working with free plugins, with WordPress, for example, then you often have a problem. Data transfer to the server is not encrypted. And now warning letters are sent, real written letters of warning from the courts and above all from the consumer advisory boards, and fines can be imposed of up to several thousand euros. Social media, Facebook, Zing, all kinds of things. The main problem in this realm are the social media plugins. Most websites have got plugins to say you can share this on Facebook, you can share this on Zing or wherever. Now, data is already flowing at that point in time. And it's not entirely clear from the point of view of German legislation as to what this signifies in terms of data protection law. You can point this out in your data protection provisions. They have to be included in the legal notice, but also in a specific separate data protection note, and it must be possible to consult that on a separate page, including on mobile devices. And in this case, it must indicate, beware, data will be transferred from this site to Facebook, even if the individual in question is not registered on Facebook at that point in time. There are also some who say that these plugins may only be activated on the web page if the user has explicitly agreed. That means that the buttons are indicated with a paler interface, and it's only when the user agrees to use the plugins that they then become active. That seems to be a fairly watertight solution, but you certainly at the very least need to provide data protection information. Cookies. There's actually an EU directive on cookies. And if you look at web pages now, you often find banner notices. They're a bit annoying because they get in the way. According to German law, you don't yet need that. That's because the EU directive has not yet been transposed into German legislation. You only need the banner with the explicit agreement to utilization of cookies if you're working with people abroad. In other words, you only need it if you're in contact with other EU audiences. If you're directed solely to a German audience, you don't yet need to have the banner notification on cookies. A few words on minimum wage. That's also relevant in terms of data protection. You know the legislation on the minimum wage, €8.50, and people are happy to write into contracts with the service providers that the contracting party can check whether the minimum wage is being paid, but that actually is not watertight because you simply cannot check up on this and obtain the personal data. This information will be useful, but you can only do so with the approval of the employee. Now, you may have heard of the notion of liability of the employer vis-à-vis the minimum wage. There are certain paragraphs in the legislation stating that contracting bodies are actually liable for ensuring that the firm with whom they are working is paying the minimum wage. And theoretically, the top-up could be imposed on the contracting company. Now, there are problems here on data protection. But actually, as a matter of fact, the provisions only apply if the contracting body should have made the personnel available directly or could have done so. Imagine you have a caterer, and rather than bringing his own staff, the caterer subcontracts out the service. Then you have this liability for ensuring that minimum wage is paid. But that's not the case if you are a standard, say, I don't know, event organizer. You don't have to have this control function implemented in your contracts, because in that case you're simply not liable for ensuring that minimum wage is paid to all possible subcontractors. Then there is event security. That's a very important and relevant topic in my mind. There's the question of recordings, cameras, theft, oversight. That is, in essence, only authorized if you have an area which is at a particular risk, for example, where the petty cash is. At larger events, what is often done is to have a camera somewhere or other, or indeed a drone, for oversight of visitor flow, to see if there's a bottleneck somewhere, to see if there's a problematic spot of overcrowding anywhere. Now, that's also a data protection problem, because you need to film in a way that ensures that individual faces cannot be identified, because, of course, as we saw before, a photo is also personal data, or you have to pixelate, or you have to make the faces so small they cannot be identified. So it's a good idea. It would be a good idea to be able to carry out checks and controls. This has been done in the UK, actually. Enormously high fines were due as a result, an absolute flurry of them. What happened was that the event organizer scanned the faces and checked against databases to see if, for example, somebody was forbidden from coming in the building, and that was not allowed. After the attacks in Paris, the German police is starting at larger events to actually do something very interesting. They take the phone lines coming into the event center, and they check them. And they do that to see whether there's any kind of bomb threat, for example. They can see where it comes from. Now, that's all very well in terms of safety and security to have this kind of tapping of the phone hotline, but they makes no sense in terms of data protections. So if you have a bomb threat, you theoretically would have to say to people, please note that your conversation may be recorded. Please could you repeat what you want? That would the only thing that makes sense in terms of data protection. And of course, the police say, well, don't be silly, just record the conversation. We have superordinate interests and we have to protect the citizens. But then along comes the regional office for data protection and says, well, if you do record everything, then there'll be a problem. And the question is, what takes priority? Is it data protection or is it safety and security and public order? And at the moment, actually, it's public order that has to take second place. Data protection is number one. You have to inform people if you're going to be recording the conversation. Now, as to data protection at events, if you don't have any questions, that would really be that, for as far as I'm concerned. But do feel free to put any questions you may have. And otherwise, you can give a round of applause and be glad that we've ended.
Haben Sie denn? Ja.
Please speak into a microphone if you're putting a question, as otherwise you cannot be heard in the interpreting booth. I believe there are mobile microphones.
Eigentlich dachte ich wiederhole die Frage, aber Sie reden so viel, das kann ich mir nicht alles merken.
Thought I'd repeat your question, but it's such a long one that I can't remember everything, so we're going to give you a microphone, sir. Now imagine that I'm a German event planner and have an event abroad, let's say in the US, and I have my participant data with me in an Excel file. I land in the US. Does that mean I've automatically violated this provision that I'm not allowed to export the participant data? Well, exporting in the data protection sense is a little different. As long as you keep them on board and don't give anybody else your laptop, then you're fine. It might be problematic, though, if you log in somewhere via a server which doesn't function as per EU data protection legislation, but if your laptop is kept offline, then that would be no problem. You would, of course, have to ensure that nobody steals your laptop, but that would be the case in Germany as well, so that nobody could actually take a look at the data.
Sonst noch Fragen?
Any more questions? There seems to be someone at the back.
Moment.
What happens if you switch from one medium to another? Let me explain. Imagine you have a personal contact on one of the social media channels, and that you are generally in touch, a kind of business contact, and ask if you're allowed to send somebody an invitation. The person agrees, and then you transfer the address into a mail program. Would the approval apply only to a particular medium or channel, or would it apply generally? Well, if you say to somebody, can I send you an advertising letter or a newsletter, and the other person agrees, and you then enter this into an email program, that will be fine. But you're only allowed to transfer the necessary data. In other words, the name and the email address. If you write down the postal address or the date of birth somewhere as well, then the person concerned has to know that it's not just their email address, their name that are noted somewhere or other. Well, it's a bit like a phone call. You said an oral agreement that would be generally binding. Well, of course, there's the question as to whether you can prove the consent, but let's not worry about that at this juncture. But of course, you can't, in such media, ask people, may I send you advertising? Because that is already advertising. Well, no, I mean, at a certain point in the discussion, if I say to a business partner, for example, may I invite you to my event? That would be all right. If you already have a business relationship, then you may put the question. Conversely, however, just because you're in a business relationship, it does not mean that you can simply send advertising just like that, by fax, by email, by telephone. But if you do have a business relationship, you may inquire. But only the requisite data may be stored in that case. Does that answer your question? Well, I wonder, what is the threshold for the definition of a business relationship? Well, the court will tell you. It's decided on a case-by-case basis. In Sing, for example, you're not supposed to just write to somebody and say, can I send you some advertising? But if you have chatted with someone, if someone is perhaps interested in the services you're offering, then you can provide them with that information. You have the purported interest or the putative interest. If you know someone already and ask them, can I send you some of my advertising, they probably wouldn't make sure that the court sent you a letter of warning at that juncture. Generally, the letters of warning come in cases when nobody has asked. There was a company that sold toner refills, and he sent us a fax, and we sent him a warning letter, and then he got in touch with us again to say he needed a hand because he'd sent this fax to all of the lawyers' offices in Karlsruhe. So asking the question is risk-free, though. You can always ask for consent. OK, well, I'll ask you again about that if I'm not quite certain. Now, there's another question over there. Go ahead. The data protection declarations, what language do they have to be in? Because after all, if you have a website, the audience will tend to be international. Does that mean that the data protection declaration has to be in English as well? Well, yes and no. The courts have not come to a clear position as to which data protection law would be applicable. Generally, you have the principle that the data protection law is determined by the seat of the company in question. So, generally speaking, it would be in German if your company was in Germany, but there's the question as to whether you might have to apply English data protection law and formulate the data protection statement in English. That's not quite clear, and there's the question as to all kinds of different countries. Some courts rule that it has to be in every single language, and then you would have 25 different languages, conceivably. And other courts say that that's not necessary, and it would be the principle of the seat of the firm determining which legislation is applicable. There's actually a case in front of the ECJ at the moment on this, and that's still pending. If anybody has any further questions, feel free. Otherwise, we can wind up.
Danke. Ich wollte fragen.
Imagine the following scenario. Last year, we had an event, and we asked the participants if we can use their data, and the next year, we write to them again with a newsletter and information on the next event. The question is that allowed because you actually only asked for approval for the previous event? Secondly, newsletters often have an unsubscribe button. Is it compulsory to include that or not? On the first part of your question. Well, the 1 year of distance is problematic. There was a Munich court which ruled that 1 year was too long a period. So just to be sure, you should have actually obtained consent to invite the participants to the follow-up event in the next year. You run the risk otherwise that a court might say that that's really too long. And if a participant only agreed at a particular point in time, then 1 year later is too long. So either you should make this automatic or point out that it's possible to unsubscribe. So this putative interest would not apply here, because you might think, well, he took part in the Congress last year, and I'm inviting him to the same Congress again, more or less, just 1 year on. The putative consent wouldn't agree because it wasn't explicitly expressed. Well, the putative interest is a notion that is defined very narrowly and is interpreted very narrowly to protect recipients of advertising. It's really a case-by-case decision. If the individual was already at the event many times in the past and had been sent advertising in the past without objecting, you could presume putative interest, but you would run a great risk because it's always linked to the question of the channel used for the advertising and the point in time which it's sent. You might say, well, this could have been sent by post. There's also the time frame, the question of whether you have consent from participants to send advertising for the next event or even the next event. That would be a much more watertight and safer solution. So thank you very much. And if you do have any further questions, you'll see me here. A big round of applause for Thomas Waetke. Copyright, event law, media law. I took a look at his blog. It's absolutely fascinating. We had a chat about that beforehand as well. His blog, eventfaq.de. That sounds better if you say it properly with the FAQ. You know exactly what I mean. So thank you very much. And he'll be here